Part 3. A clear legal framework for employers. It is important that the law is clear and that it encourages all employers to take action to help their employees with health conditions or who are on sickness absence. There are already laws which set out how employers should deal with health and well-being. But there are some gaps. The government wants your views on possible changes to the law to encourage early and sustained support from employers. It is important that any legal changes are reasonable and proportionate, keeping the flexibility within the UK labour market, which has been crucial to its success, and to recognise the differences in what employers are able to do. Workplace modifications. The law says that employers have a duty to make reasonable adjustments for disabled employees to the workplace or ways of working so that they are not disadvantaged. But there are some people who may not be protected by this law because they are not considered to be disabled. For example, those with some temporary or fluctuating conditions. The introduction of a new right to request work or workplace modifications because of their health would allow more people who are not protected by the existing law to seek help from their employer. We would like your views on whether this new right should be introduced, how it could work, and who should be eligible for it if it were introduced. Under this new right, an employer would discuss with their employee what work or workplace modifications the employer is able to provide that would meet the needs of the individual. This would encourage better conversations between employers and employees about health issues at work. This new right will be different to the duty to make reasonable adjustments, because an employer would be able to refuse a request on legitimate business grounds. Government would ensure employers had the right support to consider requests. The introduction of the new right would not affect existing protections at all. employers will continue to have a duty to provide reasonable adjustments for disabled people. Encouraging early and supportive action from employers during sickness absence. There is strong evidence that early intervention and sustained support from the workplace during sickness absence is important. However, not all employers provide this support. The government believes that there could be some benefit from strengthening statutory guidance to encourage employers to take early, sustained, and proportionate steps to support a sick employee to return to work. An employer would take these steps before an employee could be fairly dismissed on the grounds of ill health affecting their capability. It is important that these steps are proportionate. Some actions, like early conversations with employees, are likely to be reasonable in most circumstances, while more expensive support may not be reasonable for many employers, particularly smaller businesses. Reforming statutory sick pay. The government proposes to reform statutory sick pay, or SSP, so that it is available to all employees who need it, is more flexible in supporting employees, and is suitably enforced. Phased returns to work following sickness absence. There is evidence that a phased or gradual return to work from sickness absence can result in more time spent at work over the long term. For an employee, a phased return to work can help to maintain a link to the workplace, which reduces the risk of becoming detached from work and not returning. However, the SSP rules don't allow this to happen. Currently, an employee stops receiving SSP as soon as they return to work, even on reduced hours. This means that if an employee wanted to return to work gradually, for example by working half days, they could be financially worse off than if they did not work at all. The government will amend SSP rules to enable employees returning from a period of sickness absence to have a flexible, phased return to work. This would mean they could work the hours and days that would benefit them, receiving part of their wage and part of SSP. The government would create an online calculator so that employers could work out what they needed to pay their employee. Simplifying the rules. SSP is paid from the fourth qualifying day of sickness absence. The first 3 days are called waiting days. Qualifying days are normally an employee's contracted working days. The rules around qualifying days can be confusing for employers. The government could remove this rule, simplifying SSP so that every day of the week would be considered a qualifying day, with waiting days being calculated using the number of days an employee normally works, rather than specific days of the week that they work. Widening eligibility for SSP. Employees who earn less than £118 per week do not currently qualify for SSP or any financial support from their employer while they are on sickness absence. The government is concerned that employees on lower incomes are missing out on the protection that SSP provides. People may be working when unwell, or relying on the benefits system, when remaining attached to their employer is likely to be more beneficial. The government proposes to extend SSP protection to people earning less than £118 per week. Many people who earn less than £118 per week earn less than the current rate of SSP, which is £94.25 a week. It therefore wouldn't be appropriate to pay them the full rate of SSP, as this would make them better off when they are off sick rather than at work. The government proposes that these people are paid SSP at a rate of 80% of their wage. Those earning above £118 a week would continue to receive the normal rate of SSP. Compliance and enforcement. Some employees might not be receiving SSP when they are entitled to it and claiming welfare benefits instead. The government will ensure employees are paid what they are entitled to. The government would like your views on whether SSP should be enforced in a similar way to enforcement of the national minimum wage. National minimum wage is enforced by HMRC, and employees can make complaints through an online form. As well as responding to all employee complaints, HMRC proactively targets at-risk employers and raises awareness to change the behaviour of employers and employees. Early notification of the end of SSP payment. When an employee's SSP is due to end, employers must advise them of this using the SSP1 form not more than 7 days after their entitlement to SSP has ended. If notification of the end of SSP could be provided earlier than this, it could be used to prompt the employee to discuss with their employer the support they need to return to work. It could also potentially prompt them to contact their local Job Centre Plus to seek advice about other suitable job opportunities or retraining options. Longer-term reform of statutory sick pay, use of targeted rebates. Providing a financial incentive, such as a rebate on sick pay, could encourage small and medium-sized employers to adopt best practice towards their employees who are on sickness absence. This could work in a number of ways. It could be paid when the employer demonstrates a good outcome, such as successfully helping someone to return to work after a long-term sickness absence. A rebate could be made to employers who show they have adopted best practice. An automatic rebate of some SSP costs could be created in return for increased expectations placed on employers, such as requiring them to produce return-to-work plans. Or it could focus on certain employees, for example, sharing the costs of supporting sickness absence of disabled people. The government is interested in views on how the rebate could be designed. The process for claiming the rebate should be clear and simple for employers. It should give employers certainty to help drive their investment decisions, but be flexible and avoid a tick-box approach. The design would also need to consider any ethical issues around linking a financial reward to recovery from sickness. The structure of SSP. Compared with other countries, the rate of SSP in the UK is low, and it is paid for a long time. And while the UK offers a flat rate, in most other countries, sick pay is related to earnings. The current rate of SSP achieves a balance between ensuring employees receive a regular income from their employer when they are sick and unable to work, while ensuring that the incentive to work remains. Future changes to the rate of SSP could have the potential to better support employees and encourage employers to invest in supporting their staff. However, this could also mean employers taking on significant additional costs and perhaps being more reluctant to recruit disabled people. At this stage, there are no plans to change the rate or length of SSP. The government is interested in your views on the impact of the rate and length of SSP on employer and employee behavior and decisions.